to ask them of all the panelists. And I just want to give the standard legal disclaimer. Luis, I don't know if you're able to put it up there, but we're not able to give legal advice, but we can, there we go, we can point you to some resources. My name's Jessica, I'm with the London Tenants Association, and we're co-hosting this event with the London Poverty Research Centre. We're collaborating on a few projects, and one of our goals is to share information about tenant rights in our city. I'm also joined by Jeremy, who's another LTA volunteer, and he's going to be moderating the live Q&A.
Thanks, Jessica.
First, we're going to learn a little bit about our panel guests and how their organization helps tenants in London. Then we'll head into the live Q&A. So again, feel free to enter your question for any of our panel guests. We're going to try to get to as many as we can tonight. And then we'll wrap up, and the recording will be made available after the event. So I'd like to welcome our panel. Tonight we have Melissa Jeffrey, Housing Stability Bank Program Manager with the Salvation Army Center of Hope. Aulaire O'Malley is a staff lawyer at Neighbourhood Legal Services. Betsy Esbaugh is a licensed paralegal with Neighbourhood Legal Services. And Jesse Helmer, the Deputy Mayor and City Councillor for Ward 4. So Melissa, I'd like to start with you. Can you tell us a little bit about the Housing Stability Bank?
Sure. So the Housing Stability Bank is designed to provide support for low-income Londoners for various issues that may be related to their housing. So the bulk of what we do is rental assistance and utility assistance. So we can provide interest-free loans for things like last month's rent, rental arrears, and we also have a limited time grant program, which alternates with an interest-free loan program related to utility bills, such as London Hydro, Union Gas.
Okay, great. Are you able to tell us a little bit about how's the situation changed with COVID-19, and what kind of issues are you seeing?
I think since everything has kind of come to a standstill with the pandemic, I know things have gotten a lot slower for us. There's a lot of different things going on in the environment, such as the Landlord-Tenant Board being closed, and a lot of those Landlord-Tenant Board and rental arrears hearings not taking place, as well as there's also a moratorium on disconnections for London Hydro and Union Gas. And so I think given that, we have started to see a lot of the folks that are coming through our doors that are accumulating a larger amount of arrears, whether it's in rent or utilities, because some of them have been laid off or out of work since March. And with our assistance, you know, we can provide some financial assistance, but I think a lot of what we're going to have to be doing as well is connecting people to other services and resources that are available in the community to try and resolve that issue. Because as much as we do have funding available, it may not be the only answer that people need to solve some of those other issues that we're having.
Okay, great. And we can get into a little bit more of the specifics about the Housing Stability Bank later, maybe with the live questions if anyone's got some questions. Next, I'd like to head over to Aulaire O'Malley. Aulaire, can you tell us a bit about what kind of services Neighbourhood Legal provides for tenants?
Yeah, so Betsy and I are from Neighbourhood Legal Services, London and Middlesex. So we are a poverty law legal clinic. We are funded by Legal Aid Ontario and partly by the Law Foundation of Ontario. So we service low-income Ontarians, and part of our services are legal representation and legal advice regarding social assistance. So that's your Ontario Works, disability, CPP disability, and then we also do housing, but we mostly represent people who are at risk of losing their RGI housing or rent geared to income. And we also help them draft requests to reviews that are going to be filed with the Landlord and Tenant Board in case they miss their hearing, and provided that they have valid excuse on why. And we also do employment law, but mostly related to termination.
Great, thank you very much. So next, I'd like to introduce Betsy Esbaugh, also from Neighbourhood Legal. One question I wanted to ask ask Betsy is we're hearing a little bit from tenants about how sometimes legal advice can be difficult to access, and wondering if you have any tips for how tenants can get the support they need.
Betsy, I think you're muted.
I tried the space bar and it threw me off. Thank you for that. So what I was briefly just saying is that the first step is to know where we are, who we are. Coming to this broadcast, you'll be introduced to our clinic, Neighbourhood Legal Services. So you know, here we are. We're a clinic that advises and assists tenants as well as other clients and with other legal issues. But as far as reaching out to us and having some difficulty perhaps reaching out to us, it is a bit of a difficult time right now with the pandemic. Following the government's precautionary guidelines, we have closed to the public. That's not to say we're not here providing services, but we're sort of doing it in a makeshift manner, working from home. Now, the nice thing about what we're able to do is we have our receptionist at the office every day. So when you call our office, you're able to speak to a real person and explain your situation to our receptionist, and she will triage you where you need to go if we are able to help you with the problem that you have. For tenants, your first place to be referred to is our Tenant Duty Council program. And so right now during the pandemic, that will look like a forwarded call to our Tenant Duty Council where you explain essentially to his voicemail or the Tenant Duty Council's voicemail what your legal issue is, and then you'll get a call back from our office. Sometimes that results in a little bit of phone tag, but we do have a professional obligation to respond to any inquiries that we do receive, and a mandate to respond to any inquiries we do receive. So please don't hesitate to reach out to us if you do have a question about your rights. And if for some reason you feel like your call's been missed or lost in the mix, reach out to us again and we'll make sure to send you in the right way. If the phone call tag is not really up your alley, we still have our email that you can access through our website, info@nlslm.com, and you can send an email to us explaining your situation, and then we can respond by email or also by phone.
Great, thank you very much. So finally, I'll head over to Jesse Helmer. Jesse, can you talk about, does the city have any initiatives that tenants might be interested in?
Sure, thanks very much for having me on. I wanted to just give maybe a brief overview of all the various things the city does that affect tenants or that deal with housing directly. And then I think if people have questions, it's probably best to talk about the things people are interested in. So a couple that I wanted to mention. The first one is zoning. And zoning is deciding what kind of buildings can go where in the city. And that doesn't have a direct impact on the buildings that exist now, but it does affect what gets built in the future. And when new things are proposed, it's the zoning permissions that kind of shape what they look like. So that doesn't necessarily mean that it's for renters or for owners. You know, you could have a tall building that has condos in it, or you could have a tall building that has rental apartments in it. But it does shape, you know, where do the tall buildings go? Where do the medium-sized buildings go? Where do the higher density buildings go? And certainly there's a lot of rental units in the higher density buildings, generally speaking. So that's an important thing that the city does, and that's dealt with at the planning committee. We also plan out all the transportation infrastructure. So, you know, it's one place to know where you're going to live, but how do you get around? And all the sidewalks, bike lanes, transit, all that stuff is going through the city as well. Then there's more direct interventions in housing. So we will fund and partner with people to build affordable housing. And affordable housing is generally lower than the normal market rent. It varies depending on how you measure it, but it's essentially slightly cheaper than what you would get otherwise. And we will provide money up front to make sure that people provide those affordable units for a long period of time, usually between 25 and 50 years. We have some agreements that go to 50 years, so they have to keep those units affordable for that period of time. And then the city is also the owner through the London Middlesex Community Housing Corporation of 3,200 units of social housing. So these are much more affordable, rent geared to income units that the city is actually the owner of, and also the landlord for the tenants who are there. They're dealing with the London Middlesex Community Housing, but ultimately those are city units. So we're responsible for upkeep, making sure we're funding those. So like any landlord, making sure that the buildings are in good shape. And that was something we inherited from the province a couple decades ago. They transferred the community housing from the province owning it to the municipality owning it. We also do things around homelessness prevention. I'm not going to get into all the details of that, but there's also some things there about keeping people in housing, helping them get supports that they need to stay into housing. And so for some tenants, that's an important service that the city is providing. And that would include things like housing allowances or the Housing Stability Bank, which is partly funded by the city. So I think that gives you a sense of the variety of things that the city is doing. So it's not just one way that the city is involved. It's a lot of different ways. The last one I will mention, and this is one that very rarely gets talked about unless you talk to me, and then I talk about it all the time. We also set the tax rates on different kinds of housing. And most people don't know this, but about 15 to 20% of your rent is going to property taxes. And that's the city that's setting the tax rates on your building. And that's obviously something that's of concern to tenants because that's a big component of the rent.
Great, thank you very much. Before I hand it over to Jeremy with the live questions, I just wanted to give the panel the opportunity. Does any panel member have a question for each other, for another panel member? No? Okay, all right. Well, Jeremy, let's get to some questions.
Okay, I think I'll throw this one over to the folks at Neighbourhood Legal Services because it seems like it's a fairly cut and dry type situation. So Jane has commented on Facebook that her daughter actually received a letter from the city that said she was entitled to a rent decrease, which we know does occasionally happen. That has to do with, I think, AGIs expiring and things. But her landlord isn't replying to her when she sends a letter saying the rent should decrease. What are some next steps she should take? Should she pay the lower rate that she thinks she's entitled to pay? Should she call someone at the city? What advice would you give? And I think I'll throw that to Betsy, and anybody who else wants to jump in, they can feel free to after.
Sure, that's a really great question because it's not something that happens very often, like you mentioned.
Mm-hmm.
Like, whoa, my rent might be going down. That's a rarity. But sometimes when there's a sort of an extraordinary increase or decrease in municipal taxes, as Jesse was saying, that could impact the level of rent that tenants have to pay. So I'm a little bit rusty in all the nuances of the rules around communication of that change in rent, when that change becomes effective versus when a notice has to be given by a landlord. But I think this person who asked the question took the right first step by reaching out to her landlord, communicating that she received this letter and inquiring about how that reduction comes to play. If there's no response there, sometimes this happens with any landlord and tenant issue, is that tenants are not getting immediate responses or prompt responses from their landlords, and they're kind of stuck. Now what? Do I just sit on my hands and wait? Probably don't want to wait too long, because if the landlord isn't reducing your rent and you're still paying the increased amount, that'll just probably carry on forever, because the landlord won't be overly bothered that they're receiving a little bonus on their rent. So if there's a means to reduce the rent yourself, you should receive a letter that sets that out, that you can start paying the reduced rent. If the landlord is disputing that you're entitled to do that, then they can give you a notice explaining that they believe that you're in arrears of rent. And if you get that sort of notice, you'd want to come and get legal advice. Alternatively, if you find that you have made an overpayment of rent over a period of time, if your rent was supposed to be reduced, you paid a higher amount, the landlord never refunded those monies, there is a tenant application that you can file to the Landlord and Tenant Board for a rebate of rent. So the T1 application is a application about all sorts of rent refunds, and that is an application that would be available to tenants to get a return on any overpayment of rent. One thing to be mindful of is under the Residential Tenancies Act, once you pay a certain amount of rent for 12 months or longer, that may become the deemed legal amount of rent that you have to pay, whether or not you should have been paying that to begin with. So if you do have questions about what your legal rent should be, if you're not getting any insight or response from your landlord, the next step would be to get legal advice. Bring your letter that you received to Neighbourhood Legal Services, and we'll give you some more specific advice on your situation.
Okay, very good. Thanks, Betsy. One more question, just really quickly, sort of the second part of Jane's question here. Do you have any idea why she didn't get this letter specifically?
Sorry, can you repeat that?
Do you have any idea why she would get this letter specifically? You mentioned above guideline increases. I think sometimes it's a result of property taxes going down. What are some circumstances you've seen that have caused such a letter to be issued?
There's, I think, a few situations when rent can decrease, and I think you kind of briefly kind of pointed to them. So one is if there is a municipal decrease in taxes that's beyond a certain percentage point. I don't know what that percentage point is off the top of my mind, but if it's a fair decrease, I believe the landlord is required to pass on that savings to the tenant. You also mentioned above guideline increases. So many people have heard of above guideline increases, where normally your rent increases at the landlord's discretion once a month by the guideline amount, which is usually a small percentage point. 2020, it's 2.2, I believe. But if the landlord is doing capital expenditures, or there's an extraordinary increase in municipal taxes, or they're installing like security systems that are an increase in their landlord's expenses beyond their normal budgets, then they can apply to the board for a above guideline increase that could be up to about 5% over a series of years of increases. This above guideline increase has an expiration date. So when tenants get an above guideline increase that increases their rent beyond normal, that usually only lasts, say, 5 to 10 years. And at the end of that duration, the landlord is supposed to notify the tenants, hey, you've helped pay for those balconies 10 years ago. You're off the hook. We're reverting your rent back down by 3% or 4%. If your tenancy lasts that long, if you're there for that 10-year duration, you might have that situation. And another time your rent might go down is if you're losing a service that you were receiving before. If you previously had a parking service that you were benefiting from, storage service, air conditioning service, and the landlord was no longer able to provide that to you, that may also result in a reduction of your rent.
Thank you very much, Betsy. Anybody else on the panel want to weigh in on that?
Just briefly, there have been 12,700 rent reduction notices sent in the last 5 years in the City of London. And I would say the primary reasons those are happening is condo conversion. So if a building is changed from being a rental apartment to a condo, the tax rate changes significantly. So it basically gets cut almost in half. And the valuation changes. And so if someone's converting an entire building and continuing to rent them out, that will trigger a lot of rent reduction notices. And then we've been lowering the tax burden on apartment buildings in particular. So if it has more than 7 rental units in a building, we've been lowering the tax burden on those buildings steadily over the last few years, and that's been triggering rent reduction notices as well. The threshold is 2.49%. So if any of the property taxes go below 2.49, the landlord is required to reduce the rent. Unfortunately, you have to take them to the landlord-tenant board if they don't, which is not a great process.
Yeah. Okay, thank you very much, Jesse. And actually, our next question probably is a good fit for you as well, so I'll keep you unmuted. Another YouTube commenter asks, how do tenants get connected to the city's housing allowance? What are the qualifications for this program? Sorry, Jesse, did you want to take that one?
Yeah, I do. I'm just trying to get unmuted. Sorry.
Good.
So there's a bunch of different programs. So it can be a little confusing, and I'm glad you've asked the question. There are homeless prevention housing allowances, which are now available and cover about $265 per month for a household. So if that is the program that the question is about, I'm going to speak a little bit to that. So that is targeted at priority populations that are at risk of homelessness. And so it's not wide open to just anyone. So for example, if you were in a situation of domestic violence and you were fleeing that situation, you qualify for that sort of housing allowance. There's a couple of other groups, and I believe there's 6 in total, where we're really trying to focus. And these are groups where we're seeing a lot of people experiencing homelessness, people who are on the edge of experiencing homelessness, and we're trying to target those housing allowances to those groups. There is also something called the Canada-Ontario Housing Benefit. And this is something that is, as you can imagine from the name, is a federal and provincial housing benefit, which goes to low-income families. Similarly, it is targeted towards certain populations. So I think it might be easy if I'll try and track down the link to more information so that you can go and see exactly what those groups are and how to apply for that sort of program. But I do believe they can actually be combined. So you could be receiving both of those benefits, which opens up the kind of housing that people can access. So you imagine if you had a support from Canada Ontario Housing Benefit and then also a homeless prevention housing allowance, plus say Ontario Works or ODSP, now a lot more units are available for you to rent compared to what would be there without those benefits, because there's not much at that end of the market. As we know, the vacancy is very tight and the quality of the units is not very good in many cases.
Thank you very much, Jesse. And I think I want to bring Melissa in on this too, because folks who are looking for support from the city might also come to you guys for some support as well. So could you talk a little bit about how you would help someone, what resources you guys have that might complement the city's housing allowance?
For sure. So as we were talking, we do work closely with a lot of the Housing First programs in the city that kind of focus in on some of those target populations that they were speaking of earlier. So we do work collaboratively with a lot of those folks as well. A lot of those programs come to our through the Housing Stability Bank to access things like last month's rent. So if they need help transitioning out of being precariously housed or sleeping rough or being in shelter and need support with that last month's rent deposit, the Housing Stability Bank can provide that in the form of an interest-free loan. For those folks that are fortunate enough to be already housed out in the community and are maybe having difficulty in maintaining some of that, we can provide support with rental arrears. And what we can provide is up to 2 months of rental arrears based on whatever the market rent is for that unit, plus any legal fees. Because as you get along in that process, there is a fee associated with filing at the Landlord-Tenant Board, and we can include that as well. All of the financial assistance that's provided in the form of loans through the Housing Stability Bank is eligible for a 50% loan forgiveness. So for example, if you come through the program and we loan you $1,000 for your last month's rent, there's only a responsibility to pay $500 of that loan back. And I think for a lot of folks, especially those people that are on a fixed income or are starting with little to nothing to kind of get themselves going, having that last month's rent deposit or potentially first month's rent deposit in place relieves some of that financial burden so that they can, access different services and resources to get the things they need in way of, housing wares and personal needs items. I would also like to plug and mention, in addition to the direct financial assistance that we can provide through the bank, we do also have 2 staff that fill the role of money coaches. So for individuals that are looking for some added support to do things like budgeting or be strategic in how they're navigating through their expenses on a monthly basis, we have staff that can sit with them and do that, as well as help them navigate other financial services and supports within the city. And it may be something as simple as opening a savings account. We do have staff that can support individuals who are interested in doing things like that as well.
All right, thank you very much. I want to we've got a couple of comments come in. I want to jump over to Aulaire. We've got a question from David, right? And he is not very happy with the way his property is currently being run. He refers to it as being poorly managed. He wants to know, is there a way that he can get out of his lease? And I think that's a more general question. If you're upset with the way things are currently going, how do you get out of your lease, or can you?
So it depends on your lease agreement. So if you have a lease agreement that has a term for a year, it usually ends after the year. And then if you want to get out of it sooner, you can try to agree with your landlord that that you can leave sooner. You can also try to go to the landlord and tenant board if that doesn't help. But I don't think the landlord and tenant board is too keen on ending leases sooner. Usually you would have to prove that there's a lot of damage and that the landlord is not responding to your requests for repair. And then you can also file what we call a T2, T6 application. And T6 is for maintenance. T2 is for losing enjoyment of the property. So for the T6 maintenance application, you can actually ask for rent rebates as well if breaking your lease isn't an option. And then you can also ask for moving expenses if you end up moving. If the landlord and tenant board grants that your lease be terminated. And a few other things that you can ask is out-of-pocket costs for the damages caused for replacing furniture and cleaning up the unit for the damage that the landlord failed to address.
Thank you very much. Now, diving in a little bit deeper on that question, are there any other techniques that tenants can use to get out of their leases? I know I hear people talking about lease assignments and subletting and signing N11 forms and so on. Could you talk a little bit about what those options are and if they might be viable in this situation?
Sure, yeah. So definitely the tenant can try to assign or get a subtenant. The landlord is not allowed to withhold their consent unreasonably. So that way you can end up having to pay your rent, but someone else is paying it for you, but you still end up to be responsible for a subtenant.
And now what about a lease assignment? From what I understand, that's a little bit different.
I think Betsy can say more about that one. Yeah.
Sure. Thanks, Aulaire.
Sure. Yeah. So assignment and sublet are often sort of used interchangeably, but legally they have very different repercussions. So when you assign a lease, when a tenant assigns a lease, they're finding another tenant to completely step into the shoes of their lease, completely take over full responsibility of the tenancy of the lease, and the tenant that moves out and assigns it away, it has no more responsibility for that lease after the day that they're no longer a tenant. But as Aulaire was mentioning, with a subtenant situation, that's intended to be more of a temporary measure. Let's say that you're lucky enough when the pandemic is over, perhaps to go to Europe for a dream vacation for 3 months, and you don't want to have to be responsible to pay for rent for an empty apartment for 3 months, but maybe another tenant would like to live in your apartment for a temporary time. You can get the landlord's permission to have another tenant move in temporarily, but they're kind of like a guest where you're responsible for them, for their actions. If they don't pay rent, the tenant is still on the hook, and the tenancy can come to an end for all parties potentially if that subtenant is causing problems. So for a tenant whose situation calls for a more permanent end to the lease, an assignment is preferable because they're completely walking away from the lease, although the tenancy is still ongoing with another tenant. However, a challenge for somebody who wants to end their lease because of maintenance issues, they might struggle finding another tenant who wants to move into and take over a lease that's not being adequately maintained by the landlord. If that tenant asks you, hey, why are you moving out? And you say, well, this place is no place to live, that tenant might not be so keen to take over that lease. So as Aulaire mentioned, when a landlord refuses to respond to issues in the tenancy, and it comes to the point where you feel the unit is uninhabitable, the best recourse, if not the only recourse, is a tenant application where you explain to the board that I just can't live here. The problems are too serious. The landlord is not addressing them, and I need this tenancy to come to an end. The board might decide, well, we'll give the landlord a chance to fix the problems, maybe bringing them to the board. We'll put some heat and pressure on the landlord to finally address the problem. So the board is not guaranteed to enter tenancy, but if you want to walk away, the landlord and tenant board is the means to do that.
Okay. So David mentions he has 6 months left in his lease. So perhaps there's enough time there to get the landlord and tenant board involved. And I'll encourage all of you, by the way, if you have further questions resulting from this, speaking to the audience in general, please join us on londontenants.ca or on our Facebook group, and you can ask questions there, and we can share some links around and give you some referrals to some of the services that we've made reference to. Okay, next question. I think this one's probably going to go to you, Jesse, and I think you've probably seen it already. Does the city keep a record of bed bugs or bug-infested buildings? Is there a place, a repository online for tenants to go look to see if their potential building has had some problems? And also, is there a way to have property standards actually come inspect a building and speak to the landlord, or perhaps issue a work order as a result of bed bugs?
Thanks for the question. I know that unfortunately this is an issue that a fair number of tenants will run into, and once it becomes an issue in the building, it's an issue for a lot of tenants. Certainly, folks who live in my ward, in Ward 4, I've heard from many of them over the years when they've run into these problems, and they can be very frustrating. So the way that it works with bed bugs, and this is something that's in the property standards bylaw, is that the health unit sort of intervenes early on to try and help with the eradication. And so what you'll have is folks from the environmental health area within the Middlesex London Public Health Unit who are sort of the first point of contact and try and work with the landlord to get rid of the problem. Because I mean, at the end of the day, that's what people want. They want to be able to live in a place that doesn't have an infestation of bed bugs. And that's the first step. If the health unit is finding that that's not working very well, it does go to enforcement. And that's when you'll see city bylaw enforcement get involved in terms of enforcing the property standards bylaw and making sure that the landlord is doing the right thing and dealing with the infestation. So I will say that the number of times that the city bylaw enforcement actually gets involved with complaints related to this is not very many. So in the course of a year, maybe there'd be between 15 or 20 contacts. Will give you a sense of how many a bylaw enforcement would usually get across all different kinds of complaints. It might be like 8,000 in a year, and maybe 15 to 25 are pest related. So I know that it happens more often than not, and I think that's partly because the health unit is intervening and helping to deal with the actual issue, and it's not getting to the level of bylaw enforcement. But that is what you should do with as bed bugs, is to kind of raise it with the health unit, have them intervene with the landlord, try and make sure that everybody's doing the right thing. And if they fail to do that, it goes to the next level of bylaw enforcement. I did ask folks to post a link to the information about bed bugs on the health unit website.
Thank you, Jesse. And that link is in the private chat, or sorry, the private chat, the public chat, the one that you can all see. And you can go have a look at the health unit's information on that. And it's a good segue, actually, a follow-up from John, who asked the original question about city enforcement. He's curious about legal fees, and he's wondering if there is a program through the Housing Stability Bank where tenants could hire a paralegal to help get rid of infestations. And I think that would be a question for you, Melissa, if you want to jump in on that.
Yep. Thanks. Unfortunately, no, the Housing Stability Bank doesn't have any sort of grant program available outside of those legal fees that are tied directly to the rental arrears to provide financial support for individuals hiring paralegals. I mean, as much as possible, I would encourage, if finances are a concern, going through some of the local community resources such as Neighbourhood Legal Services. And I know that individuals who want to take a landlord to the landlord tenant board. In some cases, there are fees associated with that as well. But I do believe, and some of my other folks on the panel may be able to confirm, that there is an application that can be completed when applying to take a landlord to the landlord tenant board, where the fees can be waived. So you can actually take your landlord to the landlord tenant board free of charge if you meet certain income thresholds. So that would be what I recommend. I'm not aware of any other grant funding for that type of support.
Okay, thank you very much, Melissa. I hope that helps answer at least some of your questions there, John. Okay, so we have a couple of other questions. These ones are broader, a little bit more in tune with sort of current political events, Bill 184 and all that. So one question, we got this on YouTube, is can you explain the proposed changes to the RTA in collecting rental arrears owed to the tenants, if there are any? And perhaps we can segue that into a broader discussion about the changes that Bill 184, will make if it's receives royal assent. And I think I'll put that one to Betsy to start.
Yeah, so Bill 184 is a proposed bill that suggests changes over many different acts, but one of the main acts is the Residential Tenancies Act. There's a lot of proposed changes for the RTA. Some of them are good for tenants, some are a little bit more concerning for tenants. Some of the changes are more procedural about how the Landlord and Tenant Board deals with applications. Some of the changes affect compensation rights for landlords and tenants. So the one question that was brought forward was changes in rent collection. I might speak to a little bit more broadly about the proposed changes. This isn't quite signed off yet, but the proposed changes about monetary collection, maybe on behalf of the landlord. So there's a few sort of big potential changes. Some might not be as impactful as the other changes, but so one of the more procedural based changes is they're suggesting that the Landlord and Tenant Board can assist landlords in collecting rent after a tenancy comes to an end. That might include the actual process of enforcing orders for rent owing, but it is also including landlords being able to file applications against tenants after they are no longer tenants. So right now, landlords can only file at the Landlord and Tenant Board if a tenant is in possession of the rental unit. But let's say you move out and you moved out owing some rent, a month of rent, for example. Within a year after you move out, a landlord can still apply against you and say, hey, you owe me this debt for rent. That might be fair. Right now, the landlords have to go to the small claims court to do that. So it's not that tenants are safe from debt collection at this time, but they're wanting to rope it into the Landlord and Tenant Board. I think one of the broader concerns about that is the Landlord and Tenant Board is already a very high demand service, already overloaded. There's already a shortage of what are called adjudicators. Those are the judges of the Landlord and Tenant Board. And there's concerns that this will delay and slow and burden things even more. The Landlord and Tenant Board is already known to sort of balance two main principles. One is justice, of course, hopefully justice. The other one is efficiency, do things quickly, cheaply, easily, and adding more responsibilities on the board might affect access to this service. So that's sort of a flip. That's more of a procedural issue. I would also like to highlight a more substantive change, which is right now a landlord can apply to the board against a tenant for compensation of rent or for repairing damage that the tenant is responsible for. That's it. It's pretty narrow. Damage the tenant causes and rent the tenant owes. But the proposed changes are now saying, wait a minute, if the landlord owes other costs associated to the tenancy, maybe a fine from the city, maybe, what's another big one? Oh, let's say a tenant or a guest of a tenant pulls a fire alarm and then the fire department attends and there's a cost associated with that and the landlord is covering costs for those, that could be imposed on the tenant. So the tenant is facing more costs potentially associated with their tenancy and more reasons to evict them in association with their tenancies. So those are two of the big rent changes. Another one I would like to point out is some people are somewhat familiar with what's called Section 82, or the ability of tenants to raise their own tenant issues in response to a landlord's eviction application for non-payment of rent. What that means is sometimes tenants don't pay their rent when there's a serious problem in the unit that the landlord's not fixing. Now, technically, the law doesn't allow tenants to withhold rent when there's a problem in the tenancy, but the landlord and tenant board does allow tenants to say, wait a minute, maybe the reason why I didn't pay my rent is because I've had this mold issue for the past 3 years. The landlord did not listen to my request and I was at my wit's end. And when I withheld my rent, money talks, and the landlord responded. And that could play a role in defending an eviction application. And you might even get a discount or abatement on your rent for that time. Say, maybe I didn't pay 3 months of rent, but maybe landlord, you didn't do what you were supposed to do, and maybe I deserve 25% off my rent. Now my debt is lower to you. That process is available to tenants now and will be available to tenants after these proposed changes if they go through. However, there'll be more procedural hoops to jump through to access that. If tenants want to defend their application or arrears application by raising their issues in defense, they'll have to provide advanced disclosure, perhaps written submissions on what the issues are. And if they don't have all their I's dotted and T's crossed, they might be barred from defending their application, the landlord's application, with their own issues.
Okay, thank you very much, Betsy. Before we jump on over back to the bed bug issue, because I know Jesse has some additional comments there, did any of the other panelists want to comment on Bill 184? All right, Jesse, I think it's the Jesse show now. You mentioned you had some additional information you wanted to share about pests in London. So you're muted, Jesse.
Sorry, I just wanted to, I know one of the parts of the question was, can you hear me now?
Yeah, you're good. You're good. Oh wait, no,
I don't think I'm
muted.
Yeah. So one of the questions was, can you get a list of buildings? And I just wanted to comment on that part specifically, because you think that would be easy, and right now you can't, and neither can you find out where there have been a lot of fire code violations, and that was something we tried to change a few years ago, and it almost went through. We wanted to be able to post who's been getting fire code violations from the fire department, so that people could get a sense of, if the smoke detectors were working in buildings, if that was a recurring problem. And we ended up voting on that. We were going to make them publicly available, sort of like you see the restaurant health and safety inspections are publicly available. You can look them up if you want to see what the restaurant's health and safety record is. And, this motion failed 8-6, so it was very close. Councillor Mo Salih was the fellow who really brought it forward. I supported what he was doing at the time, and we're very close to making that happen in London. And I think that the dynamic would be quite similar with publishing pest issues under the property standards bylaw. And I will tell you, the London Property Management Association came out very strongly against public disclosure, making it easy for people to find out what the infraction records are for the buildings. And it was because of their sort of counter advocacy, I think, that it failed 8-6. And I think we're going to have to do that again, bring it up again to try and make those things happen, because it should be easy to find these things out.
Thank you very much, Jesse. Hopefully that change will eventually be made and we can overcome some of the opposition there and people will have a good idea of where they're moving into. Aulaire, you mentioned you wanted to add a little bit to the discussion about Bill 184, which is a sweeping change potentially to the Residential Tenancies Act, which governs a lot of tenancies in Ontario.
Yes, so part of Bill 184 is that they're making illegal rent increases permanent for, like after 1 year. So if the tenant didn't discover it after 1 year, then they're out of luck. Currently, as it stands, they have 1 year to 1 or 2 years to file with an application with the landlord and tenant board after they find out about the legal rent increase. So that's one big change that's brought about by Bill 184. And the other one is they're actually pushing for mediation to be quicker and easier. What that means, we're not sure. As it currently stands, there's already a huge power imbalance between the landlord and the tenant, even in mediation. So I think just to drop some numbers, from a study or a survey conducted by ACTO, that's the Advocacy Center for Tenants Ontario. This was done in November 2019. It said that 79.5% of landlords are represented. And if you can guess what percentage of tenants are represented, it's only 2.6. So that's a huge gap. And from that, you can clearly see that there's a power imbalance. There's, money imbalance between them. And that's why we have to be careful about what legislations are being passed.
Thank you very much, Aulaire. I really appreciate that. It's some good insight. There's going to be a lot of changes. So if you have any specific questions about Bill 184, again, please reach out to London Tenants, and we'll be posting information and articles and things as we come across them, because there's quite a lot happening. Changing gears a little bit, I want to talk a little bit about Airbnb. Kimberly has a question. She wants to know if an Airbnb is allowed in a sixplex house that she lives in. So it's a multi-unit apartment building, just under that apartment building threshold. She's had some challenges with people coming and going and parking being an issue. So I guess we'll start probably with Betsy in Neighbourhood Legal Services, but Jesse, you might have sort of a municipal opinion on that after, so we can jump to that as well. What rights do tenants have when they're living in a complex that is being Airbnb?
There is a Residential Tenancies Act component, but as you mentioned, there might be also a municipal component to this. But as far as the RTA is concerned, your specific unit that you live in as a tenant, between you and your landlord, that's a residential tenancy. That unit specifically is covered under the RTA. That's not to say every unit in a complex has to also be covered under the RTA. So there could be, you see maybe downtown, a building where the main floor is a commercial retail space, the upstairs is a residential tenancy unit. So just because you're in a complex doesn't mean that every tenant or every occupant has to be a tenant. That being said, that doesn't interfere or should not interfere with your rights as a tenant. So you're entitled to adequate maintenance in your unit that's safe for habitation. You're entitled to quiet enjoyment free of harassment and interference by the tenant, by the landlord and others. So the landlord does have a duty to tenants to ensure that tenants are getting what they legally contracted for. They're a quiet and safe and peaceful home, as well as what the contract and the RTA say. So if this other Airbnb unit, for example, is in the same complex, probably what that means is the one owner owns the whole building, and that whole building has some RTA units, might have some Airbnb units. That owner, that landlord, is responsible to you. And if that Airbnb is interfering with your tenancy, the owner has a duty to you to respond and address those concerns and fix them. So that with an Airbnb, I mean, it's relatively easy not to re-rent to a problematic guest again. You're not dealing with a permanent tenant there. But yeah, you're still protected under the RTA. So it's not a good excuse on the landlord that I can't control the Airbnb unit. Well, actually, you are responsible for it, and you're responsible to the tenant.
So, for example, if you're having difficulty parking might be considered part of your lease agreement. So therefore, the landlord has a responsibility to ensure that you are able to park. Is that a fair statement? Okay, absolutely. Yes. Okay, any of the other panelists want to weigh in? I know that it's an interesting topic, Airbnb, and there's a lot of perspectives we can take from it.
Just one thing I would add is that the city had directed, sort of council had directed city staff to start working on some regulations around Airbnb back in the fall of 2019. I think under normal circumstances that probably would have come back now. Some kind of draft regulations around what could be done in terms of regulating Airbnb and other short-term rentals. But you can imagine that COVID and the shutdown of short-term rentals basically has impacted a lot of things, including the work of the staff who draft regulations. So that's out there pending, and I expect it to come back to council in the future.
Okay, thank you very much, Jesse. So we've got another question here, and I think this is going to be best for the neighborhood legal folks. So perhaps, Aulaire, if you want to take this one or at least start us off. Meredith's got a challenge. She's living in an apartment building right now that's had ongoing issues with mold and water leakage, and her walls have been ripped open, and it's been a very long time. She's been living in her living room for 8 months with these opened up walls. I think she's curious if there's anything she can do about these mold issues and these ongoing problems that she's facing.
So I think I mentioned earlier about the T2, T6 application. She could definitely do that. But before filing, I encourage her to actually, talk with the landlord, have a record of, an email telling the landlord to address the issues and what the landlord's response is or non-response. So if that doesn't work, definitely file a T2, T6. Currently, it might not be heard soon because landlord-tenant board is only addressing matters that are urgent. So that includes like dangerous or safety issues with tenants. But so in the T2, T6, I would also encourage that she take photos of the damage to make sure that she has some evidence, make sure that it's dated. She can also try to get the health unit involved if it's a mold issue. So definitely get a report, a copy of the report if one is done, and go visit your doctor in case it has affected your breathing, your lungs. And it would definitely help you during the hearing.
Thank you very much, Aulaire. Any other panelists want to weigh in on what tenants facing chronic, serious mold or leak-related issues in properties in London should do? Okay, Betsy, go ahead.
I might just add that in my experience, I find a lot of tenants are quite patient and forgiving of the landlord for a very long time, and they endure these issues for a few months, moves into a year, a few years, and you get to the point where you're pulling your hair out 3 years later with the same issue. You're exasperated, you're so stressed out, you're at your wit's end, and you don't know what to do. You just want to move out. It's not fair. You want compensation. You don't trust the landlord anymore. There's been a disintegration of your relationship with your landlord. So just as a sort of a tip, when these issues arise, as tenants, you do have a responsibility to ensure that you are communicating with your landlord about these issues that you're discovering, disrepair issues in the unit. Report that to your landlord, as Aulaire said, put it in writing so there's a documented record of the issue being reported and the timeline and a description of the event. And ask the landlord to respond in a deadline. Take the power back. Dear landlord, this issue is happening. I want to hear from you within 7 days about how you're going to address this problem. Take control over the timeline and the response. And if the landlord isn't acting reasonably based on what the issue is, take the next step. Do another letter, file your T2, T6. Don't wait 3 years based on empty promises or non-response by the landlord. Act quickly and promptly and get these issues addressed in due time so you're living in a more well-maintained and hospitable place sooner than 3 years down the line.
All right. Thank you very much, Betsy.
Just add something to that. So most of the time it involves furniture being thrown out. It's very hard to get compensation from the landlord-tenant board or from your landlord to replace costs for furniture. So I know it's not optimal, but keep a copy of the receipt your furnitures. If ever you have to throw them out, at least you have some sort of evidence saying this is how much my furniture was and this is when I got it, because it's very hard to get compensation for that.
Okay, it's good advice. I wish I had the receipts for all my furniture. I don't have any furniture. I'm just kidding. I live in a black room. Okay. John actually has a follow-up question, and I think this one is probably going to be relevant to any of the panelists who've got experience dealing with the Middlesex London Health Unit. He says that per his interaction, MLHU has stated they do not assist with bedbug infestations, but may do so for a courtesy on a case-by-case basis. That sounds a little bit different than what you were describing, Jesse. So perhaps he wasn't talking to the right person. Do you have any idea why he might have experienced this with the Middlesex London Health Unit? Excuse me.
That would be surprising to me. I've had some dealings with the health unit, as tenants have had problems in their buildings and have involved me because they've been reaching out to the health unit. And I've always found them to be willing to go and talk to the landlords about what needs to be done. But, there are a lot of people who work there. And I think depending on the situation, maybe some people are doing things differently than others. So I guess one thing I would suggest is that if you do run into an issue like that, I think your expectation should be that, the health unit will say, contact your landlord, tell them that there's an issue. If they don't do anything within 2 weeks, we will follow up with them. Like a public health inspector from the health unit will follow up. If you're not getting that kind of response from the health unit, my email is jhelmer@london.ca. And you could reach out to me directly, and I'm happy to follow up with the health unit to make sure that everything is being done the way it should be.
Thank you, Jesse. Quick follow-up, and again, I'm not sure if this is going to sit with you or Neighbourhood Legal Services, so I'll start with you, and if somebody from Neighbourhood Legal wants to pick it up. Penny asks about mice, so different kind of pest, and she was told that the health unit wouldn't deal with mice or rat issues, and apparently she was getting batted around between different agencies. So in your experience, is that something the Middlesex London Health Unit will get involved with? Other types of issues around rodents and other pests?
Well, I answer that one. So they do have a very specific focus on bed bugs, and it's interesting where it comes from. There was funding that was provided probably 10 years ago by the province to do sort of education work and public health promotion work around bed bugs and how to handle them about 10 years ago. And it was one-time funding, and ever since then, the health unit has been involved pretty directly in bed bugs. But you can imagine that different kinds of pests have different kinds of profile in terms of their health risks. And really, the health unit gets involved in ones that are a significant risk. And so, I think they have looked at the property standards bylaw. If anyone's actually looked at it, you'll see that there are specific species named and not everything. And so there's a bit of a back and forth between property standards and bylaw enforcement and the health unit. And I would say for bed bugs, you're well in hand to be contacting to the health unit. But you want to talk to property standards and bylaw enforcement if you had other kind of pest issues. We want to make sure that people are living in a good situation. Sometimes, people run into situations that make us need to revise the property standards bylaw, right? They see things that are not covered. There's a gap in the way that we're trying to regulate things locally. And sometimes if those issues are identified, we can go and change the bylaw so that more things are covered. So, it depends on the specifics of the situation. What kind of, is it one mouse or is it a whole bunch of mice? Is it like a rat colony, or is it, one rat every once in a while? So, I think it depends a bit on the facts, what the response will be. But for something like a rat, it's probably going to be property standards rather than the health unit.
Okay. Does anybody from Neighbourhood Legal want to weigh in? Or if you have opinions on rats, Melissa, of course, you are more than welcome to jump in as well. I assume that you've experienced this before. Go ahead, Betsy.
I just want to say that from a legal standpoint, one of the benefits of contacting an agency like the Middlesex London Health Unit is evidence gathering. So hopefully, and on a practical level, the health unit will respond, address the issue, communicate with the landlord, and maybe work towards resolving the problem. But from a legal standpoint, if you get a report from the health unit verifying, yes, this indeed is an infestation issue, that goes a long way in verifying your issue to the landlord and tenant board, especially if the landlord decides to deny the existence of the issue or the awareness of the issue. You can say that you've gone through these three third-party authorities first. You're more likely to show a stronger case to the landlord and tenant board.
All right. Thank you very much, Betsy. Much appreciated. Excuse me. Okay. From, I believe it's a YouTube user, Nobody Home. He's curious about N12. So for those of you not familiar, an N12 is a personal or purchaser use eviction form, essentially asking you to leave your home in order for somebody else to move in who's legally entitled to do it. So Nobody Home says his landlord or her landlord is selling and gave us an N12 dated end of June. We have no other paperwork from them. We don't want to move. What should we do? And this is a fairly specific case, but generally, what is the correct response to an N12 during COVID? And Betsy or Aulaire, if you want to take that, I think that's a neighborhood legal issue. Go ahead, Aulaire.
Sure, yeah. So N12s, you don't need to move out the moment you receive the N12. So all your landlord would do is take you to the landlord and tribunal board landlord and tenant board and evict you, get an order to evict you. So you definitely don't need to move out right away. And if you think that your landlord is bluffing or doing it in bad faith, you could definitely raise those arguments at the landlord tenant board. And you never know, you might just keep your housing. Also, given the current pandemic, I don't think the landlord tenant board is issuing any eviction orders for N12s, so your landlord might need to wait. There's only certain N12s that have gone through, but those are like really, really urgent statuses.
Okay. Now thinking about some of the possible use cases, and this is sort of my exposition on the question, sometimes N12s are issued on behalf of an individual who owns the property. Sometimes they're issued on behalf of a purchaser. If a tenant refuses to move out as a result of an N12 that's otherwise valid, were it not for COVID, basically, could they be held liable for, say, a real estate agreement not going through, like a transaction? Is that something that they should worry about?
Well, that's very hard to prove, and it's not going to be under the landlord and tenant board. It might be small claims, or depending how much it is, it might go through the entire course of justice. But generally, it would be hard to prove that a deal fell through because the tenant didn't move out. Because what just happens if the landlord sells the property, the buyer steps into the shoes of the landlord, and then they could facilitate the N12 if they needed it. And then if the tenant chooses to move out by the N12 and later on realizes that it was given to them in bad faith and that there's another tenant in and they just raised the rents, they can file a tenant's application with the landlord and tenant board and ask for the difference of 1 year for the difference of the rent, their new rent and their old rent.
Okay, thank you very much. Do any of the other panelists have any opinions on that issue, the N12 issue? Okay. All right. This is another question that I think will probably fit best with our friends at NLS. So David asks if you guys are familiar with the backlog of the landlord and tenant board given COVID. So if a case is filed now, let's say, just a normal run-of-the-mill case, how long before they can expect to have a hearing? And I'll throw that to Betsy, I guess, because you've been doing a lot of the tenant duty council stuff.
Yeah, no idea. To my understanding, that's not publicized. I believe that the board is continuing to accept all applications, and they are slowly opening the type of applications they are resolving or hearing through telephone hearings. So there is a slow trickle of applications being resolved right now, but not compared to what they used to be. So before COVID, in London specifically, there would be 2 to 3 hearing days a week, where at a Monday morning there'd be about 80 eviction hearings for non-payment of rent. And then in the afternoon on Monday, there'd be another about 10 eviction or tenant applications mixed. Tuesday, the same thing, about 20 mixed applications. So we were getting, 100 to 150 cases heard a week. Now, with COVID, the hearings that they're slowly starting to hear, they schedule them one at a time over the phone with a case management officer or an adjudicator. If there are 3 hearings in a day, maybe, versus 30 to 100, that's a big difference. But the board at this time, as of June 25th, has not yet sent out an update on when they intend to open. Some tribunals have, some courts have started planning the reopening of their systems, but the Landlord Tenant Board has not. So it is a big gamble on when you might find yourself at the board if there is an outstanding hearing. But if you are a tenant debating on whether or not to file a tenant application, I would say don't wait, file it and see when your hearing might come up.
Okay, that's good advice. So just for the folks watching at home or wherever they happen to be, you can file some applications digitally over your computer. So that'd be the T2 and the T6, I believe, which are some common tenant applications. That can be done. And you can also apply to have the fee waived, as I believe Melissa mentioned earlier. So that's going to be valuable information for some folks. Okay. So we've got a couple more questions here that I think are going to fit in well with the neighborhood legal services theme, but I encourage our other panelists, if you have a perspective that you'd like to add, please weigh in, because it's really valuable having you all here. So this is a question.
I just want to chime in kind of after Betsy finished there. As much as things are kind of really slow and doing a slow trickle through the Landlord Tenant Board, as much as possible, I encourage people that if you are currently owing rent to call the Housing Stability Bank and start that process, and don't wait until things get to be more than what you can manage. Like I said, we can help with up to 2.5 months of rental arrears plus any legal fees. So if you're kind of sitting in that range as far as what you're owing, come in sooner rather than later, because as much as possible, we want to try and resolve the issue in its entirety. And I would also like to say we have a few different avenues in which people can apply. So people can contact our offices directly by phone and leave us a voicemail, and they will receive a return call. They can contact our office at our email, housing@centerofhope.ca. And our new exciting news is we have now an online application that's available for rental assistance and last month's rental, available on the Center of Hope website. So if you go onto the Center of Hope website and search under what we help with and go into the Housing Stability Bank, there's a button there that you can click, and that will take you in a link to start the application process. It's relatively new. It just went live last Friday. But once that application is completed, that will go into our general housing email, and a Housing Stability Bank worker will be in touch to follow up. In lieu of that, as much as possible, we're also encouraging, even if you can make partial payments to your landlord, we strongly encourage people doing that, and then they can come to us for the larger part of the balance should they need it. Our utility arrears application will be live on the website probably sometime in July. So again, just encouraging people to reach out to us. I would say right now the volume of our program remains fairly low. So I don't know if people are waiting to address the issue until we're on the other side of COVID. But I would strongly encourage people not to do that and come in sooner rather than later.
Okay, another follow-up for you really quickly. So we know that back when COVID first hit, late March, early April, there was some confusion about the obligation to pay rent. From what I understand, tenants are still obligated to pay rent, and they will likely be found to be responsible for any arrears that they haven't paid. Is that accurate?
As far as I know there was some things going around where they were talking about tenants banding together and avoiding paying things like April's rent. I can say that gave me gray hair because unless there's going to be any rent forgiveness coming down or mandated by, like, people are still going to be held accountable for what they owe. So like I said, as much as possible, even if you're making smaller partial payments, do that. Come to us and we can help you with what we can do there. We can also try and connect you with other resources to help offset some of the other expenses people may have.
Excellent. Well, thank you very much, Melissa. We have a couple more questions sort of trickling in here, so I'll put them to you guys. One question, and this I think is going to fit well actually with Neighborhood Legal Services and with Jesse in your capacity at the city. Nobody Home, our YouTube friend, asks, can tenants who move into a city contracted rent controlled unit access the landlord and tenant board for illegal increases? So the question here is, will the landlord and tenant board enforce city contracts if the tenants can prove their unit is in a city contract? So I think that has to do with arrangements between the city and private developers to keep the rent a certain way. And perhaps some landlords may have increased the rent despite being required not to. So perhaps I'll start with you, Jesse, to talk a little bit about programs like that, and then we can shift over to Betsy or Aulaire for a follow-up. Jesse?
Sure. So the way a lot of the agreements are structured with the landlords or the developers from the city's perspective is that they are required to keep those units affordable for a certain period of time and at a certain level. But the level is often written in a kind of formula. So it's relative to the average market rent in many cases. And so that will change over time. So that's not to say that just because a unit is a city contract, that it wouldn't be changing the price. So the price could be changing, but if it's above what it should be, the first step I think would be to advise the city that somebody you think is in breach of the agreement that the landlord has with the city, because that would be the first point where it could be enforced and where you could see some relief. Because unlike a situation where you're not in a city contracted unit, the only real dispute resolution there is to take it to the landlord tenant board. In this case, you could conceivably appeal to the city and talk to the city first, and the city could talk to the landlord about following the terms of the agreement. So I think in terms of other options, you probably better to listen to Neighborhood Legal Services, but contacting the city housing office, advising them of the situation, explaining what the change in the rent has been, what you think it should be, I think would be a good first step.
Okay, thank you, Jesse. I guess I'll throw it over to Aulaire. Have you ever seen a case like this before where essentially a city property developer agreement has been breached and taken to the landlord and tenant board? I think you're muted, Aulaire.
Sorry about that. So yeah, I'm not quite sure if it's a city contracted unit, but definitely there's some illegal rent increases that's happened in the past that were certainly heard at the landlord and tenant board. So I guess the rule of thumb for rent increases is it should only happen once a year, and that the tenant is entitled to a notice of 90 days, and the rent increase should only be 2.2 for 2020, and then it depends on which year you're at. So those are roughly the rules on rent increases, and anything above that or not outside of those rules, you can definitely bring your landlord to the LTV. Excellent.
All right. Okay, so we've got a couple more questions here. We are going to target a finish at 8:30 to respect everyone's time. So we'll trickle out and then we'll do some conclusions in a little bit. Okay, we've got two questions here that are sort of more related to the behavior of landlords and enforcement and different agencies that might be involved in that. So Penny comments, and I'm going to phrase it as a question, that she finds that landlords often engage in, or in her experience anyway, negative or harassing or bullying behavior, and the landlord and tenant board isn't much help. And she finds that there's sort of an element of income discrimination there for folks who may be on OW or ODSP. I guess I'll ask our panelists, is this something that, that you've experienced? And if somebody is experiencing a situation like Penny described, what recourse would you suggest? And perhaps Betsy, as a tenant duty counsel, you might have a perspective on that.
There's a kind of complexity to that question and those sort of situations that might apply to. From the perspective of finding yourself at the landlord and tenant board dealing with this kind of situation, when you're talking about the conduct of parties, the landlord's behavior, it's kind of hard to prove that somebody maybe said something or did something or conducted themselves in a pattern of behavior that was inappropriate or harassing without video evidence, audio recording, police reports. So when you find yourself in a situation where the landlord is untrustworthy and perhaps harassing you, the best thing you can do is try to collect evidence of that. If you can't find a way to record it, you can even just make notes. Have a little dollar store notebook, somewhere inside your rental unit, and every time there's an incident, make a record of it, the date, the time, who was there, who was involved, and what was the issue. And every time an incident occurs, add it to the list. That's a very good piece of evidence to demonstrate that the landlord's behavior is inappropriate. But as far as finding yourself at the landlord and tenant board, there is a tendency for tenants to feel like they're the underdogs. Aulaire mentioned earlier in the meeting, or in the session, that landlords are often represented. They often come off as an authority figure. They come off as very experienced and educated in the law and landlord and tenant business practices, and sometimes their voices might feel more dominant. That's not to say that they're right. It's important for tenants to recognize that the landlord and tenant board is there to balance the power, to protect tenants, and tenants need to be aware that they are entitled to safe and quiet and peaceful enjoyment of their homes, and just do your best to make a recording of any incidences that arise that are threatening to you, and put it on the record too. If something happens, write an email to your landlord. Dear landlord, I didn't appreciate the conversation we had. Going forward, if there's a problem, please correspond to me in writing, alerting me to the issue. Period. Yours truly.
Thank you very much, Betsy. I wanted to throw a form of this question over to Melissa. So you help tenants who might be experiencing some financial difficulties. And we know anecdotally, and we run a tenant group, so we hear a lot of complaints and observations like this, that sometimes landlords don't like renting out or dealing with folks who they don't perceive as being income stable or gainfully employed or whatever. Is this something that you've experienced in your work with tenants, that landlords have reacted negatively to the Housing Stability Bank's involvement? Do they know about it? Is this something tenants should worry about?
Unfortunately, yes, I can say that we have encountered, whether direct or veiled degrees of discrimination to the folks that we typically serve. I think a lot of the landlords, especially some of the bigger landlords in the city, are very familiar with our program. One of the benefits of coming through the Housing Stability Bank is once the application is approved, the funds are 100% guaranteed. Mm-hmm. We do work really hard to maintain a lot of positive relationships with the landlords in the city. But I have seen, especially more recently with the vacancy rate being as low as what it is and some of the average market rents being a lot higher, landlords now have the luxury of really cherry picking their tenants. So there's a lot of applicants for one particular unit. And while they may not come right out and say, I'm not renting to you because you're on social assistance, they may put other barriers in the way that will indirectly eliminate some of those folks. Kind of keeping in that, looking on the rental arrear side, I do think there has been more of an interest from landlords to work less cooperatively with some of their more long-term tenants. If somebody's been in the rental unit for an extended period of time, 5, 6, 7, 8, 9, 10 years, and they fall behind in arrears, we'll do what we can to financially support them and get them caught up. But the landlord might be more readily willing to move ahead with an eviction as opposed to doing something like a mediated agreement, because they know that if they can get that tenant out, that's paying a market rent that was done with a controlled increase 10 years ago, and they can get that person out. Now they can increase that rent up to today's prices. And so there's a lot more of a financial motivation to do that and turn over some more of the long-term tenants. So unfortunately, we do see it. But I like to think, you know, the Housing Stability Bank works really hard to maintain good relationships both with tenants and landlords, and we can kind of in some ways act as an advocacy or mediator between the parties, but it really does depend. Some landlords simply will just make the statement that they won't accept any third-party payments, which makes paying them from our program a lot more difficult, but we are always looking at ways that we can improve turnaround time on payments and things like that. Landlords can accept payments from us either by check or by electronic funds transfer. So as much as possible, making that process as convenient and seamless for them as possible.
Excellent. Sounds like a great program. Thank you, Melissa. Okay, we've got a couple more questions, and then I'm going to throw it to you guys to give us a little bit of a closing statement. So start jotting down notes now.
Jeremy?
Yeah, go ahead, Jessica.
Can I just make a quick comment? Just on that point about the landlord-tenant board and access to justice. The London Tenants Association has initiated a couple exciting research projects with the London Poverty Research Centre, and we want to look into exactly that, some of the barriers to getting access to justice. So we're looking into things like developing a formalized peer support program where we can provide support to tenants who are having difficulty accessing justice, but also we're doing some academic research with some students from King's College and the University of Western Ontario about the impact of unlawful evictions, which Melissa was mentioning, are becoming more common with the incentive to get long-term tenants out. So those are a couple things that we have, and we're hoping to uncover some of that data and those gaps in the research projects that we're doing. But I'd also want to say to anyone who is experiencing that, even now, please reach out to the London Tenants Association, either through the Facebook page or info@londontenants.ca, and we'd like to find out how we can provide support however we can.
Thank you very much, Jessica. Can't forget the plug, and that was a good one. We've got two more questions. One of them is for you, Melissa. It's about the criteria to qualify for the Housing Stability Bank program. So if you have sort of some high-level bullet points that you share, things that you should be or have if you would like to access the Housing Stability Bank.
Yeah, for sure. I'll kind of break it out because there are a few different things that we focus on. So the first one being last month's rent. Unfortunately, we don't have the capacity as a program to help people locate and secure housing. So a lot of that legwork has to be done before they come to us. So whether that's getting an intent to rent form, or if they get to the point of signing a lease, or maybe it's just having the contact information for a potential landlord for a unit that they're interested in, they can bring that information to us. And what we look at in order to qualify somebody for a loan is we do look at that they qualify under our income criteria. I won't get into detail about it, but basically they're low income and their income doesn't exceed certain levels. From there, there is a small budgeting exercise that we do in the application, just looking at general sustainability, but it also helps to highlight where we can make referrals and warm transfers to other services and other programs in the city that person may be able to use to assist reducing costs on food and electricity and things like that. From there, we contact the landlord, let them know we're looking at going ahead with issuing a payment, and then get their details, whether we're sending them a check or banking information if they want a deposit, and from there we'll pay out directly to that landlord. with rental arrears, what we require typically is that somebody has some form of eviction notice. Usually the first notice people are given is the N4 notice, or they have a hearing already scheduled. Given everything that's going on in the environment, we're kind of soft on that. So if people are 2 months behind or 3 months behind in rent and their landlord hasn't issued an N4, I do still recommend that they call our office and start the process. And the rental arrears application looks very much the same as the last month's rent. So looking at the income, generally the sustainability of the household. And what I would like to say is, typically we do require any loans somebody has previously with the bank are paid in full before they access the program again. But with everything, there's always exceptions to the rules. So as much as if people don't meet certain criteria, we can always look at doing exceptional circumstances, which means we're kind of going outside of our regular rules and boundaries because there's an urgent and compelling circumstance that warrants that additional consideration. So we can help people who are relocating into the City of London, but unfortunately, if somebody is deciding to move out of London and into another community, we're unable to assist them in that way. So it does have to be an inner city rental within the city boundaries. In regards to usually they have some sort of notice of disconnection and they have to have made a $50 payment in the last 4 months. With the grant program, people can be eligible for up to $500 towards the electricity portion of their bill and up to $500 grant towards the water portion of their bill. And the loan is very much the same.
That's excellent. That's fantastic information, and I hope everybody was vigorously taking notes. Just kidding. We're releasing this as a recording, so
our flyer's on the website. So.
Very good, very good. So I want to squeeze in one final question before we wrap up. As you're aware, I'm sure all of you who've dealt with landlord and tenant issues, when the police are called about a matter that involves a landlord and a tenant, they very often will refer to the landlord and tenant board and just back out of it. John has had an experience in the past where he feels like the police aren't taking him seriously when he calls about landlord harassment. Is there any advice that you would have generally, Betsy? I think I'll throw it to you, and we'll just do our best to keep it quick.
Oh boy, and what a good way to end the conversation, how to deal with the police. So yeah, the police services are a great service in the City of London, looking after, the safety of all, citizens and occupants of our city. But they're not necessarily always fully informed on everyone's legal rights, and all the legislation that applies, including landlord and tenant. So sometimes they don't fully understand all the rights of tenants, all the exemptions of the Act, and sometimes not everyone's completely honest with the police. Landlords or tenants might sort of persuade a police officer to act in a certain or to make a decision about a landlord and tenant dispute. Ordinarily, police should not be getting involved in landlord and tenant disputes at all. If there's a safety issue, someone's safety is threatened, if there's an act of crime happening, perhaps a police presence is there. All you could do when a police officer arrives is try to be probably reasonable in your communication with the police officer, and explain to them that this is your home, that you rent out this property, and you ask that the police officer respect that, and the police officer should be aware of the landlord and tenant board process. But if you find that you've had a negative experience with the police officer, and in regards to your landlord and tenant relationship or your tenancy, I encourage you to reach out to our office and let us know if that has happened. We are developing a good relationship with the local London Police Services in helping to educate them and identify scenarios where to help educate how police officers should respond when they're brought to a scene for a particular complaint. And if, I'll jump to the worst case scenario, you're illegally locked out and the police officer helped the landlord escorting you off the property and you've been illegally removed from your home. That's not the end of the story. You still have rights. You still may be legally entitled to access your home again. What you want to do is contact our agency, contact the Rental Housing Enforcement Unit, and we can help you correct the situation.
Okay, thank you very much for that, Betsy. All right, we are coming up on the half hour here. I want to thank all of our panelists. Melissa, Betsy, Jesse, and Aulaire. We really appreciate having you here today. As always, please come visit us on our website at londontenants.ca. With that, I guess I'll go in order. I'll say, Melissa, do you have any 2 or 3 sentences you wanna share, and then we'll sort of go down the list. I'll call on each of you.
No, I think as much as everybody is, we're all kind of just waiting to see what's on the other side of this pandemic. I think definitely in the city, there's going to be people that are coming through our doors and are accessing our program who've maybe never come through our doors before and are finding themselves in situations that they don't really know how to navigate. So as much as possible, we're here to help them in any way we can, as well as if we're not the answer, connecting them to the other services in the city that might be available and more appropriate for whatever they're bringing forward. So I just want to thank you for having me. It was a great conversation, and I hope that everybody found the information helpful.
I certainly did. Thank you so much, Melissa. Aulaire, if you have any final words that you'd like to share.
Yeah, well, first, thank you for having us, and thank you to everyone who tuned in. So I guess it's important for tenants to know their rights, but it's also important for them to read everything that they receive from the landlord or the landlord and tenant board. So if it's a notice of hearing, read everything. That's where you'll find some resources. That's how you can connect to Tenant Duty Council rather than knowing about it on the day of your hearing. But definitely read everything and try to reach out to our office or Tenant Duty Council for more advice.
Thank you very much. Betsy, I'll jump to you. Just good segue.
Sure. Yeah. Thank you for having us. Thank you for joining. And I appreciate all the questions. I encourage all tenants to keep asking questions, keep having conversations about their housing, their experience, the information they've learned, and support each other. And we'll do our best to support the community as well.
Thank you, Betsy. And Jesse, last word goes to you.
Thanks very much. I just wanted to, I know lots of folks who are tuning in are probably pretty politically active, but I wanted to just emphasize the importance of getting involved and showing up and voting when elections are happening. A lot of really important things are decided by the people who get elected. People like me, also people like the MPPs who get represented to represent you at Queen's Park. The changes to the Residential Tenancies Act, the dramatic cuts that have happened to legal aid. We have 2 people on here from Neighbourhood Legal Services. The cuts that were made in 2019 were on the order of like 30%. So you could imagine for every 10 people there are, like the 2 panelists we have, 3 of them didn't have any funding anymore last year. And it was going to be even worse than that until people started to push back pretty substantially. And those cuts have been kind of put off for the time being. But you can imagine cutting people's legal representation, especially people who have low income and don't have a lot of other options, at the same time as you're changing the act and making things more difficult for tenants. That is a double whammy that makes the situation of tenants much worse. Similarly, the rules that get set at the municipal level, what kind of buildings can be built where, what kind of transit's going to go where, that is all decided by the people who get elected. So not just at elections, but also throughout the year, make sure you're reaching out, put pressure on elected officials. When we talk about stuff like should we put fire code violations, make them publicly available, try and raise your voice so that people know what you think about it. Because the landlords and the property owners, they definitely show up and they're always talking about what their interests are. And tenants have different interests, and we need to make sure that as much as we can, we're showing up in all those spaces, talking as much as we can about the issues of tenants. I think the Tenants Association is a wonderful improvement for London, and there's a lot of issues that need advocacy. So in addition to working on your own issues, which I'm sure you're running into, try and help other folks out. Make sure you're voting for people who are going to help tenants and not do things that are going to be harmful.
Thank you very much, Jesse. And with that, we'll call it a night. I'd like to thank all of our panelists again. Jessica, thank you so much for introducing us and participating in the hosting duties. I also want to shout out our friends behind the scenes, Luis, Tina, Michael, and Shand. We couldn't have done it without you, and we look forward to having you back for another one. So with that, have a great evening, and we'll see you in the next one. Please visit us on our website.